Nitika 401, can we start? We are 137 participants now.
Okay, sir, we can start. So, good afternoon, everyone. I welcome you all in today's webinar. This is a webinar series where we are reviewing regulations notified by Insolvency and Bankruptcy Board of India. This is the 8th webinar, which we are conducting every Wednesday. Today's topic is IBBI IU Regulation 2017. So, for this specific regulations, we have Mr. Debajyoti Chaudhuri, sir. He is the MD and CEO of NESL, and he is an MBA and a certified associate of the Indian Institute of Bankers. Prior to joining NESL, he was the Chief General Manager at Insolvency and Bankruptcy Board of India, and he took their some path-breaking initiatives like the implementation of the company's registered value and valuation rules 2017. So today, Mr. Debajyoti Chaudhuri, sir, will explain how this IU regulations were formed, what was the motive behind that, and what are the changes which are required under IU regulations. He will also make all the insolvency professionals aware about these regulations. So over to you, sir. Plus, from NESL, only we have Mr. Shankar sir also. He is also associated with NESL for a long time. And Chaudhuri sir, we have Pankaj Khitan sir also. He has been the moderator in all our sessions for last 6 or 7 sessions. So he will also actively participate. He is an insolvency professional and has handled various assignments under the code.
Okay, thank you. So thank you, Nitika, and thank you, ICICI for having me here to present this IBBI Information Utilities Regulation 2017. And I'll just give you the salient features of these regulations, and then I'll also cover a few areas where some amendments could be brought in to further strengthen it. But before that, I'd just like to dwell on this fact that this information utility is generally regarded as the fourth pillar of the IBC. And when IBC was notified and CRPA was started, IU was not in existence. But today, IU information utility, NESL has a wealth of information, and that can be used by all the players of the ecosystem. And of course, we shall also see how it can be useful to the insolvency professionals as well. So, Aisha, if you could come to the first slide. So I'll just, this is what we are going to cover. And these are the regulations, and these are in 8 chapters. The first chapter concerns the registration, eligibility, conditions, and renewal for registration process. There's a second chapter. First chapter is just basically the definitions and other things. The third chapter is about shareholding and governance. And fourth chapter is very important, the technical standards, because we are a fully electronic repository. That's why the technical standards assume a lot of importance. Then chapter 5 covers the code services. Code services, as you are aware, it would as provided in the code. Chapter 6 talks of duties of information utilities. And chapter 7, important for you, which is services which the IU offers to insolvency professionals. And chapter 7 is relatively less significant regarding the surrender or cancellation of registration. So let's look at these chapters, and let us see how these regulations have been made to benefit the ecosystem. So just move to the next slide, please. Yeah. So before that, before we go to the regulations, we'll just talk of the forms which are in use. Form A, of course, relates to application for certificate of registration, which is, of course, should not be of use to anyone except for a person who wants to apply for registration. Form B is about the actual certificate of registration itself, which is issued by IBBI. Form C is one which is quite important, which the form in which user has to submit information to the IU. That is detailed in Form C. And finally, the most recent form is Form D. This is also extremely important. It's important from the insolvency profession also, especially if he's an IRP and he's associated with the initial application for initiation of insolvency. So this record of default can facilitate admission of insolvency proceedings, and IBBI in a recent amendment has specified the format in which the record of default is to be issued. So this is called Form D. Okay, the next please. Now, the regulations provides for conditions for registration as an information utility, and these conditions have been framed so that there's some rigor and only serious players are registered as a information utility because they store critical information. And so some of the conditions I've just put in this slide here, which is that it has to have, of course, have a sole object to provide core services and other services, has shareholding and governance chapter as per chapter 3. So there are some requirements. No single entity can have more than 10%, subject to some exceptions. So with those exceptions, it can be up to 25%. And governance, there are provisions for governance also, which I'll detail in subsequent slides. There has to be bylaws, and why that's important, we'll see in the subsequent slides. A minimum net worth has to be of 50 crores. Then an extremely important provision that fit and proper persons as its promoters, directors, its KMPs, and persons with more than 5% directly or indirectly of its paid up equity share capital. So all these persons have to be fit and proper, and what is fit and proper is also provided in the regulations. Now, information utility is an electronic repository. That's why the regulations also provide that the information utility should be having technical competence and financial capacity required to function as information utility, with recoverable secure systems for information flows along with business continuity plans. So in case of a disaster, there should be a business continuity plan. We do have a business continuity plan, which has been approved by IBBI as provided in the technical standards. Adequate infrastructure and data processing systems, which provides unauthorized access, as also destruction, disclosure, or dissemination of information. So it's an electronic repository. It has information of companies. So it's very important that unauthorized access or destruction is, we have systems in place to ensure that it does not happen. Finally, a functionality to ensure privacy and confidentiality of information. Information is there with us, so we have to ensure the privacy and confidentiality of information. And of course, as I stated earlier, the technical standards laid down by IBBI and its bylaws, which should be inconsistent with the provisions in the code. Next slide, please. So, as I stated earlier, there are provisions for the governance. Corporate governance has to be of the highest standards, and these are provided in the regulations. And the regulations provide the composition of the governing board, which should be managing director, there should be independent directors, and there should be shareholder directors. And the regulations also say that the number of independent directors cannot be less than the number of shareholder directors. And for this purpose, the managing director, that's myself, is not considered either as a independent director or as a shareholder director. Then for the appointment also, the criteria is provided in the regulations, and the qualification, experience, manner of appointment, terms of term and condition appointment, and other procedural formalities will be subject to the guidelines issued by the board from time to time. Similarly, for independent director also, it's provided that should be an individual of ability and integrity, has expertise in the field of finance, law, management, or insolvency, not relative of the directors of the governing board, without any pecuniary relationship with the IU, not a shareholder of the IU, and not a member of the board of directors with more than 10% of the share capital of the IU. So all these provisions are there to ensure that there is highest level of corporate governance as far as the information utility is concerned. Okay. Bylaws of the IU are there, and these bylaws it's provided that should be consistent with the code and provide for all matters attaining the technical standards. And the bylaws provide for manner and process of providing core services and other services under these regulations. Risk management is extremely important because we have substantial data with us. Minimum service quality standards, including timelines for registration of users, registration, issuance of record of default, issuance of annual statement to registered agents. I know timelines are there in the code and in the regulations, timelines for every activity. So timelines are extremely important. And that's why timelines are also it is bylaws say that bylaws provide for the information utility to have service quality standards, especially on these three activities. Similarly, the bylaws also provide for adoption of quality standards and quality standards certification. You would have seen in the initial slide that via ISO 27001:2013, it also provides for rights of users and also grievance redressal. Next slide. Yeah. So obligations of IU are there in the code. So I thought of course this is we are reviewing the regulations, but since the regulations also follow from the code, so I thought I'll just bring a reference to this. The code provisions, the code, and section 214 provides that the information utility has to provide core services such as create and store financial information, acceptance of electronic submission of financial information, meet the minimum service quality standards. We saw that it's already there in the bylaws. Authentication and verification for financial information. This is an extremely important provision in the code, and that makes the IU very unique. It is often said that the information utility as an institution has no parallel in the world. And this fault, that is because any information which we get, which is submitted to us, has to be authenticated and verified by all parties to the same. If it's a financial creditor or a operational creditor is submitting, then the information has to be present to the debtor. And if the other parties like co-applicants or guarantors, so the information is presented to them as well. Providing access to information. So this is also core services. Since you have information, you also have to provide access to the same. So access is as provided in the regulations. We'll see this later. And IU is not a public credit repository. Access is only to authorized persons. And we'll see later who are those persons. Publish the statistical information as may be specified by the regulations. 36A provides for this publication of such information, and information utility has been publishing this information. This is there on our website. Actually, you can move just on the bottom. If you could just put hide there, because it gets some of the text gets obstructed. Yeah, thank you. Now, in the regulations also has a reference to the core services, and regulations provide that IU shall provide core services and other services which may provide services incidental to the services under core and other services. So this incidental service is extremely important, and we'll see that we provide this case management solution, which provides for the entire CRP, right from issuing of notice by the operational creditor. So entire process can be done through this case management, and this service is provided under the 17.2 under incidental services, the services under core and other services. And of course, while providing all these services, it is the regulations provide that the IU shall comply with the applicable technical and technical standards while providing the services. Now, a user for submitting or accessing information with the IU has to register himself. And the IU shall verify the identity of the person and grant registration, and also provide a user a functionality to enable its authorized representative to carry on the activities on its behalf. So this is a very important provision that a person has to identify himself and then register himself, because information in the IU has evidentiary value. And once a person is registered, suppose it's an entity, it's a company or LLP, then a registered user functionality to enable its authorized representative to carry on the activities on his behalf. The acceptance and receipt of financial information is through Form C of the schedule under IBPI IU regulations. And on receipt of information, IU acknowledges its receipt and notifies the user with a UDI. UDI is unique debt information. So every debt in the IU, every loan in the IU has unique reference number, which is generally the PAN of the submitter along with the account number. So every account number is stored separately as a distinct record. Terms and conditions and authentication verification information, the manner in which the information may be accessed by the other party. So the moment the information is submitted in this Form C, so IU will acknowledge the receipt and also notify the user with the unique UDI, the terms and conditions of authentication, and the manner in which the information may be accessed by other parties. Now this regulation 21, that is the last bullet, 21A. So this was introduced very recently, and it provides that before filing the application to initiate corporate insolvency resolution process under section 7 or 9, as the case may be, the creditor shall file the information of default with the information utility, and the information utility shall process the information for the purpose of issuing a record of default in accordance with regulation 21. So this was issued on this regulations were notified in 14 June 2022. Effectively, it means that any applicant under section 7 or 9, before he files the application, he has to file the information of default with the information utility. Okay, next. So regulation 21 is very important, and it provides for a process for the authentication of information of default. So any information which is submitted, you will of course expeditiously take up the process of authentication, verification, information of default. And how this is to be done? So it will deliver the information of default to the debtor seeking confirmation of the same. And then it has to remind the debtor at least 3 times for confirmation of information of default. In case the debtor does not respond, allow 3 days each time for the debtor to respond. Then deliver the information of default or the reminder either by hand, post, or electronic means at the postal or email address of the debtor. And this email address is to be delivered in a sequence which is provided in the regulations. And the email sequence which is to be used as registered with the information utility, failing which recorded with MCA 21 and the certified registry as repositories or any other statutory repository as approved by the board, and failing which submitted in Form C of the schedule. So what it means is that we have seen on the top in B that the information utility has to remind the debtor at least 3 times for confirmation information of default. So which email ID is to be used? So for that a sequence has to be followed. The email ID which the debtor has used while registering with the IU. So if that fails, then the email ID which is there with MCA 21 has to be used, MCA 21 or CERSAI. And if that also fails, it is to be used in the email ID which is provided Form C by the submitter of information, which is usually the financial creditor. So, and this is where I think we have suggesting a change. In fact, we are suggesting that the sequence should be kind of reversed. And the sequence should be, firstly, it should be sent to the email ID provided in Form C of the schedule. and secondly with NCN 21, and thirdly, if it is registered, if the IU is, if the debtor is already registered. So why we are suggesting this change is that the creditor usually has the updated information regarding the debtor. So he'll be in a correct position to give the information related to the debtor. That is one. And secondly, the debtor may not be registered with the IU. So that's why we are recommending a change in the sequence, and it also helps in saving time in the process. For example, if you use the first one and then the email bounces, then we go to the second one. So effectively, some time is lost. So here we are suggesting a change, and it is stated in bold, in red, bold, so that we are suggesting a change that first should be used what is there in the Form C, then the NCA 21, and finally, if the debtor himself has registered with the IU, so that can be used. Okay, next. So once the this authentication process is started, so IU has to issue this, record the status of authentication of information of default with color codes. So there are three kinds of color codes where the debtor confirms information of default. Disputed is where the debtor disputes information of default, and deemed to be authenticated is where the debtor does not respond even after 3 reminders. Of course, it is stated there that in case of financial creditors, which are banks included in the second schedule of the RBI Act 1934, information utilities will record the status of authentication of information of default with color codes as under. There are only 2 color codes in case of banks which are included in the second schedule of the RBI Act. So what happens after this authentication is complete? So the record of default is issued to the registered users who are creditors of the debtor who has defaulted in payment of a debt, and also to parties and sureties, if any, to the debt in respect of which the information of default has been received. So there are 2 elements of significance here. So when the mail is sent, so it is not a question of sending a mail. So the IU information has to ensure that the mail is delivered. So how we ensure is that if it's an email, we get a delivery status from the email service provider that the mail has been delivered. So since till the time the mail is actually delivered, this process cannot be completed. So, and then there are 3 status, and the record of default is issued with the 3 color codes, either of 3 color codes. If it's a bank which is there in the second schedule of RBI Act, there'll be 2 color codes: authenticated and disputed. Authenticated where the debtor confirms information of default, or the debtor does not respond even after 3 reminders. So in these 2 cases, green is used where the debtor disputes information of default. The color code of red is used. Okay, next. So 21A is was inserted later, and it says that the IU shall disseminate every public announcement it receives or access to on the date of its receipt, or access as the case may be, to its registered users who are creditors of the corporate debtor undergoing insolvency proceedings under the code. Now, just to elaborate here, what is the public announcement we get? One is the public announcement, of course, we see, which the IP makes, inviting claims subsequent to commencement of CIP. So that is one we get. The second information which we get is regarding filing of application. So it's not really a public announcement, but this is a facility which IBBI has enabled by way of a circular, and so this information comes to us, and this is designated to our registered users. So here again we are suggesting a small, it's not really amendment to the regulation, because the regulations already provide for this, but we are suggesting that even this Form G, which is for invitation of expression of interest, so that also can be provided. And how that will help, because there are a number of registered users, and if this Form G is sent to them, so that could be useful. Some of the registered users may be interested in this in the CD for which expression of interest has been called for. So this could be very useful. There's another regulation, which is regulation 25, which provides that every user IU has to provide every user annual statement of all information pertaining to the user free of charge, along with the functionality to mark the information as erroneous and correct it. In fact, this I had talked earlier of authentication and verification information, and there's a very important aspect of the IU which makes it very unique, is that any information which is submitted by creditor, or financial creditor, operational creditor, is presented to all the parties to the debt, and they have the opportunity to either accept it or dispute it. So, and also a financial creditor who submitted information, he also has to be given the functionality to mark it erroneous. So this functionality has also been provided, and this is also provided in the regulations. Next. So this is an important provision, this regulation 23. It provides that the following persons shall have access to information stored with information utility. The user, of course, which has submitted the information, has access. All the parties to the debt and the host bank, subject to conditions. There are some conditions to this. The corporate person, there is auditor. Now, D is extremely important because it provides that insolvency professional, to the extent provided in the code. So insolvency professional has access to the code. This is a very unique opportunity for the information professional. He can use it to access the information to the CD. What kind of information is there? And this could be used for verification of claims. This could be used for preparation of IM. So it could be very useful to the IP. And recently we made access to the information even simpler. So all that IP has to do to access information is just to give the order in which he has been appointed as the IRP or RP to the resolution professional. So if he just gives that order, so we'll be giving him access to the information which is there in the IU. And I would encourage all IPs to use this access provisions. And how will it help? It will help in seeing what are the kind of creditors who have filed the information in the IU. He can, information utility IP can compare it with the claims which have been filed. He could, if some claims are very high compared to the information, what is there in the IU, he can ask for the questions. And very important, if any creditor has not filed his claims, but his claims are there in the IU, then he can take it up for submission of claims. So this information is very useful, and IP is in a unique position because he has access to the records of the CD in the IU. So all IPs are encouraged to use it. And in fact, till date, more than 100 IPs have used this facility. So besides that, of course, the A has access.
Excuse me, sir. Sorry to interrupt. Is this a paid, service?
No, it's a free service. It's a totally free service.
Free service.
Absolutely.
Thank you, sir.
The only requirement is that you have to give the order in which you have been appointed as IP to the CD. So only with that we'll give you access. And as stated earlier, this process of access has been even simpler, made even simpler very recently. So
thanks,
besides
sir.
that,
thank you.
Yeah, thank you. So besides that, we have the A which has access. We have the IBBI, of course, we have access. Then what can user see? The date the information was last updated, the status of authentication, the status of verification while providing the access. So when we provides access, so all these details can be there. And effectively, if you see as an IP, you will find a lot of other data also. For example, default has been filed on which date. Then you can have access to the office of the CD. What kind of security given by the financial creditors? So a wealth of information is there. So you always encourage to use this facility. Next. Now, the regulations also provide for certain duties of the information utility, and it says that the information utility has to provide services with due and reasonable care, skill and diligence, without discrimination in any manner, and hold information as a custodian. Information utility also has to provide services to user based on his explicit consent. And a very important provision is that it has to guarantee protecting the rights of users and their records by adopting secure system of information flow and establishing adequate procedures and facilities to ensure against loss and destructions. So all these are there in regulations 28, 29, and 30. Adequate arrangement including insurance for indemnifying the users for any losses which happen. There's a provision relating to fee also. And then risk management framework has to be provided, and this is to provide for all matters, including reliable, recoverable, and secure system, provision of core services during disasters and emergencies, and of course, a business continuity plan which shall include disaster recovery sites. And I would just like to elaborate here that our data center is like a bank. It's a tier 4 data center. We have a data center plus a disaster recovery site located in different seismic zones. And as I stated earlier, we also have a business continuity plan which has been approved by IBBI as provided in the technical standards. Finally, there's also a requirement to audit the information technology framework, interface, and data processing systems through an external auditor. So this has to be done annually every year, and this report has to be placed in our governing board as well as to the to IBBA. Then there are provisions for a preservation policy. So all records have to be preserved as per the provisions in the technical standards. Can you just next slide, please? So this was in 36A was introduced in April 2021, and it provides that information utility has to publish statistics related to debt-related information in its possession at quarterly intervals. This is there on a website, and these statistics contain the details of distribution of debt in terms of currency, geography, sector, size, tenor, type, lending arrangement, and incidence of default. So all these are published by way of separate reports, and this is there under our in our website under the tab statistical information. So this is published as quarterly intervals. Regulation 38 is extremely important, which is regarding services to insolvency professionals. Insolvency profession may submit reports, registers, and minutes in respect of any insolvency, resolution, liquidation, or bankruptcy proceedings to an information utility for storage. So this can be information utility can be used for storage, and I think it's very effective because we see that various measures have been taken to ensure information security. So I would encourage all IPs to use this facility. And finally, once this is records are provided for storage, the regulations also provide that IU shall not provide access to these reports, registers, and minutes to any person other than the concerned insolvency profession, the board, or the AA. So you can be rest assured that this information will stay secure, safe, privacy and confidentiality will be maintained, and it is available only to these to the IP, the board, or the A. Other than that, it's not available. So that is one comfort you have, that all records will be safe. Besides this, as I had mentioned earlier, we also provide this integrated case management system, and which has been permitted by IBBI under Regulation 17.2. And end-to-end case management process is provided right from the time of demand notice by operational creditor to this EOI to RFP. We also have a provision for having auction facilities. So it's a end-to-end process, and the same security is available. The data center, the disaster recovery, end-to-end case management. It's totally digital. It's totally paperless. So that facility can also be used. Next one. Okay, I think this is the final slide. Now, this provision is related to IBBI CRP regulations, but we are suggesting some amendment to this so that it can be of use to the insolvency profession, because this regulation, it says that the existence of debt due to the financial creditor may be proved on the basis of records available in the information utility, if any, or other relevant documents, including a financial. So various other documents are provided. So what we are suggesting is that, if the records of information utility can be used, so it will be of great help to the IP, because he does not have to look beyond the information utility. And in any case, because for financial creditors, information is required under the code, is mandatory under the code to submit information. So this information is already there, and that can be readily used. More important, this information is submitted with the digital signature of the submitter. So it has legal validity. So if this is done, and today actually, unfortunately, if any provision is there and along with other documents, so it is used. Yeah. So yeah. So this can be effectively used for verification of the claims, and it can make the the task of the IP easier than what it is now.
Shri sir?
Yeah.
There is some facility of recording the information in your utility for 7 8 years, like 4 5 years.
I'm getting a lot of crosstalk actually. If everybody else could just mute their mics. If one person can speak, I can make out.
Actually, there is some facility of storing data in electronic for a company for 3 4 5 years. There is huge data, and we have some space. We can save. We can save the data for future reference for 3 4 5 years.
Yes, it is there. It is there. At the conclusion of the process, you can store the data with us. And if you are using our ICMS, you can store on the go. So during a process itself, you don't have to worry about saving the data. If you're using the ICMS services, it can be stored. It is kind of stored on the go. So you can, whatever work you do on the ICMS platform gets stored automatically. Ayush, you can stop presenting now. You can just remove the presentation.
Excuse me, sir. Sir, can we have the a separate session on the demonstration of services provided by NESL through IPA, so that there is awareness of what kind of services are being provided, and then so people can know how the facilities can be used, how they are useful, and demonstration how to operate and how to use those facilities.
Definitely, I request Nitika to coordinate that. I would request Nitika to coordinate that. We'll be more than happy to do that. See, one thing I'd like to stress here, this information utility is like it is a national asset. It is something unique which has been created, and it is there for the ecosystem. And IP is an integral part of the ecosystem. It is there for all the ecosystem members. It is there for IBBI. It is there for AA. It is there for the public. That's why we publish statistical information. But insolvency professional is the fulcrum of the entire insolvency resolution process. So definitely we can have a session. I request, I think Shankar, we can request Nitika to have this session. And Nitika is also here. So Nitika, you can have a separate session on this.
Can we explain what changes we are recommending to ICSI IRP for NESL regulations?
Yeah. So I think I had covered it during the presentation, but
particularly we can go through regulation wise because that was during the your deliberation. So
Yeah.
it was
So
difficult to
yeah,
capture that point.
So maybe Shankar, can you run through that? I think I made it in red. If you can, Ayushi, you can just have the presentation again. So I think I had already covered it. We can cover it again.
You
if
have
want.
covered it, but
We'll
Nitika
cover it
has
again,
to-
no problem.
Nitika
So-
has to note it down, now.
Shall I
Yeah,
show
we'll-
the regulations, sir?
Just have the presentation once more. We'll show you. We'll send the presentation also. Don't worry. You can just get the places where we are suggesting a change. So that is one thing I think I'd explained here. This sequencing can be changed. Because see, what has happened is that most of the time, the creditor is the email of the creditor is used. So that's why this sequence could be changed.
Okay.
Then, see, right now, of course, this doesn't require amendment, but this needs to be activated, every public announcement. So like Form G is also
sir,
public announcement. Yeah.
The Form G is available on the IBBI website. So can we link it from there? Because
Yes,
it
yes.
will,
Yeah.
it
So
will
typically,
create an
see,
extra burden on the IP.
no. So please, Pankaj ji, let me just explain how it happens.
Yeah.
So IP को कुछ नहीं करने का है. So
Okay.
generally, what happens is public announcement also it flows through an API from IBBI.
Okay.
And then it's disseminated. So
Okay.
IP has not to do anything.
Then
So
it's there.
similarly, Form G also IP will simply give it to IBBI and it will flow through us through our through an API. And
So-
we in turn will disseminate to all our users. See, what will happen is the system will benefit because we have more than 350,000 companies on our database.
That's
And if we
great.
talk of total debtors, we have more than 2 crore debtors. So इसमें से anybody could be a resolution applicant.
Yes. So, sir, here it is mentioned every public announcement. It means Form G is also the public announcement.
Yes.
So separately, it's not required to be.
Yeah, but
mentioned.
if we can, but if we can, and specifically, we have also taken up with IBBI, but if from ICICI IP also it could be taken up, it will be good. As I
Then,
Sir,
because,
sir,
every public announcement word is mentioned here.
Yeah.
So it means NECL can have the access of the even sale notice also.
Yes. Everything can be flows through this thing,
Yes,
so
yes.
we can, we can destinate to our users, and you are likely to get a better response because it will reach out to
Yes,
maximum number of
NECL
people.
has a huge database, so
Yeah.
IP will get the benefited
Yeah.
from that database.
Yeah.
If IBBI, if their website can be linked for the sale notice as well as Form G also.
So then it is not required to be published in newspaper.
Form G is required to be published.
Of course, the Form G besides all these things.
Sir,
Besides
Form
Form-
G is required.
sir, Form
Form
A
G is
also, no?
required. Form
then
sale
formally is also
auction-
required to be published in newspaper.
Yes,
then.
auction
Yeah,
notice
form-
is also required.
Form A has to be also, sir, published because English and
This is the
Yeah,
regulation.
language
Yes,
में
yes,
requirements
so-
है.
So basically all public announcement.
Yes, sir.
So that can be, that's the internal working between the IBBI and the NESL.
Yeah. But
And
it
sir,
will
one
help,
question.
because if
Yeah.
if ICCI and as an IP also, if you can put this across, it'll be easier.
Yes.
Sir,
Next.
one question. All the financial creditors are now putting everything on NESL. At least if we talk about public sector banks, they
All
these,
banks, not just public
yeah.
sector, all private sector, every NBFCs, everything is there. Even debenture trustees are there. If you
It is
see
a- it is a-
recently, see, there was recently an order in which Catholic debenture trustee, they have used a record of default for initiation of insolvency proceedings. So even debenture trustee information is there.
But is it, sir, mandatory for them? I mean, even the private
Yes.
sector banks are doing
Yes,
it, or
yes,
no?
yes,
It is
yes.
optional.
Yes, it is. It is mandatory. The code provides for it. 215, I
Okay.
think 2 of the code provides for submission information. RBI has also given directions to banks to submit.
Yes, I have a question.
Okay.
Actually,
I-
when IP registers himself, but he is unable to see what the financial creditors have really mentioned about that particular CD or any debt.
Even
No.
sir, I also feel that way because I also have a couple of experiences where it was not very exactly had they really put it
No,
on
to solve
information
this
utility
problem,
or not.
no, to
Yes,
solve
sir.
this problem, if you have any
Yeah.
specific case, we can immediately show you.
Okay.
No, I am registered with you, but for
just show
to
me
check
that.
one
Just show me.
CD,
No,
when I
we'll help.
checked it,
So who's this speaking now, please?
I am Shankar from Chennai.
Yeah,
I
please.
switched on camera. Probably you can see
Yeah,
that.
now I can see. Now I can see.
Because the bandwidth I switched off.
Yeah,
See, when I want to check the debts, actually, whatever has been registered in the NESL, that IU portal, I am unable to do that actually. In spite of my registering there as an IP and also giving that password, everything, login ID.
Okay, so Shankar, can we help this?
Yes.
Can we help? So we are
Yeah.
noting
Yes,
your
sir.
contact.
Yeah,
So
please.
we'll get in touch with you immediately after this
Yeah.
webinar or
No,
tomorrow
okay,
morning.
okay, sure. Sure.
So
Sir, repeat your name, sir. Shankar.
I am Madurai Sundaram Shankar.
Madurai Sundaram Shankar.
Yeah.
So, we have this helpline, and also, Shankar can also give his mobile number. So
Yeah,
please do reach out to us. Yeah, you can note down, Shankar.
59950.
9788.
59950.
Okay.
We'll be more than happy to help you.
Chat, sir. Yeah.
Yeah,
And
please, if
please
you reach out,
remember-
it will be really great for me.
Yeah, it is absolutely free of cost.
No
if you-
issues, but
Yeah.
whether actually I should know really what is happening there in the website. So
Yes.
to know about the debt, definitely it will be very helpful for the processing of the claims.
Yes, absolutely.
Sir,
Yes.
is it not better that the information on the debt and default should be taken from the creditors, bankers, rather than going in from the debtors, because from the bankers you'll get the exact authentic information on debt or default or whatever is the outstanding debt. I think that will be better if you directly take it. And sometimes debtors, they do not even respond to the mails from NESL, or they do not give the authentic information. So it's always better that you create a database out of the information received from the bankers, financial institutions, etc.
So who's this speaking?
Yes.
Who's this speaking?
Anil sir, Anil Chinda.
So Anilji, this is what I said. The information is coming only from the banks. We are getting bank information with the digital signature of banks. And because banks are mandated to the only thing which I said, and I'll just clarify once more, and that is what makes the IU unique, is that once the bank submits the information regarding a debtor, we present the information to the debtor to have his views on the same. Right? So if a debtor wishes to contest it, he might say, no, the interest rate is not this much which I agreed to. Or he might say the margin which I have agreed is not correct, or the security is not correct. So then he can record his dispute, or he may say outstanding is not correct. But information comes only from banks through a digital signature, so it's authentic information.
Got it, sir. Thank you.
Thank you.
May I ask, sir?
Yes, please.
Sir, it is a little different question. In fact, the regulation, information utility regulations makes it compulsory for the operational creditors as well as financial creditors to register the default. Now, if I go to the section 15 of the...
No, there's a lot of disturbance coming. I don't know it's coming from where. Request others to please mute their mics. There's a lot of disturbance coming. Yeah, now you can go ahead.
Sir, as per the regulation, it is compulsory to file default with the information utility, both for operational creditors and financial creditors.
Yes, please.
Now, as against this section 215 doesn't mandate compulsorily for the operational creditor. Now, sir, the last thing is that there is a circular. There is a circular from the Ministry of Corporate Affairs that is dated 18th January 23. That is after the regulation that was came in June 22. Now it says that the government is considering to make it mandatory for the operational creditor to register their default with the information utility. So my question is that as of now, is it compulsory to register the claim before the information utility in case of application under section 9 of the IBC.
Yeah, so if you see that this NCLT order and also IBB has issued a circular. So it is, if you are wanting to initiate, I think, can we show that circular or that order? Do we have it somewhere? Can Shankar, can you show that? IBB circular, we can show that it is there. Shankar, can you show that on the screen? So if you are initiating an application under 7 or 9, then you have to file submission information of default with the IU. Now tell me, Mr. Shah.
Yes, please.
So what is the issue there? Any problems there in submitting information?
So the problem is that I had filed an application that was after June 22. So I understand that the NCLT will definitely ask to file the default with the information utility.
Yeah.
But the recent circular that has been issued by the Ministry of Corporate Affairs, that is
no, Ministry of Affairs. No. See, Ministry of Corporate Affairs has not issued a circular. Which circular are you referring to? Yeah. Which circular are you referring to?
Sir, it is file number 30/38/2021, Insolvency Government of India, Ministry of Corporate Affairs.
So dated
18/1/23.
18th March 23.
18th January.
What is this circular? Shankar, have you seen it?
No, sir, should I read one paragraph?
Yeah,
so should I read one paragraph? Section 215(2) of the code makes it mandatory for the FCs to submit financial information to the IUs. In the event of a default, the record can be presented to the EA to determine that the default has in fact taken place. While submission of such information,
there's a lot of disturbance. I'm sorry, I cannot hear you. There's a lot of disturbance.
Sir, this is a proposed amendment, sir.
This is a proposed amendment to make it compulsory.
Correct. Sir, that is proposed amendment which will come in the code itself for all operational creditors to submit default. Here in the regulation 20, this thing has been changed. 21A was inserted, amendment, and it was inserted so that at the time of going to NCLT, you have to file the application and get an ROD. In the code, when it comes, all defaults, whether you want to go to NCLT or not, all defaults have to be submitted to NESL IU. That is the idea.
Sir, my another question, it is a practical problem. In any case, I had filed the record of default with the information utility, that is NESL. But wrongly, I have given information in form C, that is for financial creditor. I have to give it for operational creditor. So can I change it?
No, form is same form, sir. Same form.
Is the same.
Form is the same.
Yes.
Yes, sir. Sir, I can share that is RBBI circular, sir.
No, it's okay. I think now it's clarified. Huh? And one more thing, Mr. Shah, now we have a dedicated record of default helpline. So any issues regarding, in fact, information, just flash that record of default helpline, please. Anybody has an issue, any queries, any understanding regarding information of default, you can call that mobile number, which is answered by one of our officers. Can you send, Ayesha, can you just flash that? Record of default helpline.
Take into account the willful defaulters?
Yes, for anyone. That way we don't distinguish between willful default or otherwise.
Yeah,
Just
see, actually, when a PAN number is put, the willful defaulter will always come out, actually. Whether any debtor is also marked with a willful defaulter if it is notified by the RBI.
We don't have access to that. That is a very secret database. That is not available in the public domain. We don't have access.
You don't have access.
Yeah.
But the lender is supposed to inform you that he has made the debtor as a willful defaulter.
No, that's not. As of now, the lender is not required to do that. See, whatever lender has to do is there in Form C. Okay, so just show that record. So you can just kindly note this. Any issues regarding to record or default, this is a mobile number for one of our colleagues here. And he is there only to address queries related to record of default. Is it fine? Yeah.
The record of default only to be given to you, or any amount due can be given. Sir?
No, I
Hello.
cannot. Go ahead now. Go ahead.
Sir, only default has to be given, or
Yes.
any due, whether it is fallen or not, amount due from a particular person can be.
Any amount which has become due and not paid. So that is a default.
All
So
the other
that
information cannot be put in.
Yeah.
Which
So
is not due.
no, see, if you see the record of default, it has given in Form C, it has provisions for both the amount of default and amount of debt. So both needs to be given. There's a format in which you have to give this information, which is there in Form C. So if you all that information which is there in Form C, it has to be provided.
Okay, sir. Okay.
Chaudhuri sir?
Yeah.
Can we discuss the regulations, like what all changes the IPs need or the changes in the regulations, like since we have half an hour?
Yeah, we have already given that. I don't think we have any more changes. There's 3 or 4 changes which you have suggested. No?
Maybe the IPs would have some suggestions.
If you have any suggestions, we are happy to listen to it.
Yes. So shall I share the regulations?
Yeah, please, Nitika.
So mostly I discussed this during the PPT, but we can present it.
I would like to request all the fellow IPs to give your suggestions, what they want to change in the some amendment or some amendment. I think Nikita, we have to move to Mr. Shankar's.
Nikita, can you increase the size to be more visible to the full screen?
Yeah, now it's fine.
Fine, thank you.
Nitika, kindly mute Mr. Shankar's.
A lot of background sound is coming.
Yes. Lot of background sound is coming. Yeah, I request all the fellow IPs to kindly mention regulation wise we are going through. It's our fortune that Mr. MD of NESL is with us. So we can discuss our suggestions which we want to give to IBBI for the amendments in the IU regulations. It's the definition part. Would we require any changes in definition part?
The definition can scroll up.
Okay. Nitika, next. Yeah, scroll it down. Scroll it down. Yes. Eligibility for registrations.
I think we can. It is.
Sir, it has a minimum net worth. Okay, it's for IU. Check next. It's the internal matter of IU. Application disposal, that's the internal matter. IP is not where come in between this. Yeah, next. Next. It's the internal guidelines. Yeah, same thing here. Yeah, registration of user, next 18.
Please go slow.
Yeah, next it's the procedure.
That a person registered with one IU should not register with another IU. Is it? Why is that it is restrictive?
No, it's not restricted. Let me tell you one thing. As of now, there's only one IU. So
I know, sir.
No,
I know.
why this is provided is to make the life of the user simpler. So that if there are multiple IUs, he is not required to register with multiple IUs. That's the only reason this is done.
Okay.
This
As
to
of now, there is only one IU. I know.
Yeah. But future also, if there are multiple IUs, so if a person has to register with multiple IUs, it becomes his life difficult. Huh? So this is just to make the life of a user, which could be you yourself, much easier.
So one point comes here.
Yeah.
For bankers, SARSAI is there, CIBIL score is there.
Yeah.
So why not NESL? Government makes one agency for bankers also, that is NESL, because it has the huge database, and even CIBIL score, like CIBIL score, NESL scoring facility shall also be provided.
No, just one thing, you must see that, the purpose of all these repositories is different. Okay. Like, I think who's speaking? Mr. Matthew is speaking, right?
I'm Pankaj Kheta.
Acha, Peta, sorry, Pankajji. So, the purpose of all these repositories are different. So, CIBIL is mainly for credit assessment, but NESL is evidentiary value. So that's why if you see CIBIL, you don't have to submit under digital signature. Any information to IU is under submitted under digital signature. Secondly, if you submit information to the IU, you have to also identify yourself. Why this is being done? So that if it ever comes to court and ROD is actually, evidence of default, it can be used for admission. So all these things help in establishing default.
Yes.
So identity, digital signature, and then part, whenever, if you recall Section 7 application, initially when it was there, the question was always asked whether the notice has been given to the corporate debtor. So our ROD is complete. If in a ROD, if you see, there are all details of communication with the corporate debtor. So if you present one ROD, it is one complete document. So all these repositories, the purpose is different. IU has been established specifically as a evidentiary value for the AA to take a decision on whether there's default or not.
So it means NESL is only for the IU is only for the IBC sake of thing.
For the time being, yes, but we are looking at other things also. For example, we also have a digital document execution. Right now, see, when you are uploading documents, when a FC has to file application, he has to submit photocopies of documents, right? So when a document is digitally executed, it can be just the digital copy can be uploaded, physical copies may not be required. In fact, AA rules are right now being amended, because right now AA rules say that 3 copies of the applications need to be submitted.
Yeah,
so
that's true. That's true, sir. But so then it is only for the IBC related matters.
No, that's why I'm telling you. We are also providing a document execution facility. So tomorrow, when the FC wants to use this for IBC, he can use it, but he can use the documents elsewhere also. Okay. Document execution to वैसे भी होता है ना.
But execution, see whether if there is any default registered with NELC, that bankers can utilize it for the DRT matters or for SARFAESI matters.
Yeah, there's no reason he cannot. But as of now, it has not been enabled. But since it has evidentiary value, it can be used anywhere.
Okay.
That is one. Pankajji, we also have something called ICMS, which I had mentioned earlier. So this also we have been this is provided under 17.2 of IU regulations. So this is also an integrated case management software to take care of entire processes in CRP and liquidation.
This is only a hypothetical question. Can a person engaged in research, can I access the IU information?
So 23 dikhaiye, just come to 23, you get the answer yourself.
Okay, sir.
Who can access? Nobody can access. Nobody. Short answer, no.
No. Okay.
But it's a valid question. Personally, I would like this to be done because we have so much of data and this data can be used for research. You are absolutely right. But as of now, regulations do not provide for it. We are working on this. Let me tell you that this is already under our consideration. We are looking for some way out. But as of now,
because it is the confidential data, that's why it is not available for the public domain.
Yes. And also because regulations are very clear who can access.
Yes. Because NESL IU is governed by this regulation. That's why they are not opening their window.
Yes.
And you said digital signature is mandatory.
for submission of information. For submission of information, for authentication of information, digital signature is mandatory. But today,
For accessing information?
Shankar, can you just explain? Access information, I think.
So for accessing information, you are an IP when you register. Once you register, login and password will be given to you. Using that, you can do that.
Okay, clear that. Okay. I
have
got it.
So
question.
just to
I have
clarify,
one question.
only for submission of information, digital signature is required. Accessing not required. And
Today-
IP process, IP access is even easier because we can identify you by a registration number.
There are two kinds of
I was
digital
trying to
signature.
register while working on it with this IU, but they were seeking the which entity you are registered with. So that they have given red mark. It is required that the IP should be registered with some entity. IP.
No. Why
It was
Shankar, you please note down Mr. Shri Singh, huh?
Yes,
Please,
this challenge.
please, no entity is required.
So it was showing red
No.
color when I was trying to attempt to register with, so it was not getting registered.
Let me just clarify. Earlier, this registration was a two-step process. One, you had to give your NCLT order, and secondly, you have to get the CD registered. But now it is only one step. So you can call Shankar. You can note down his number, and we let us see we can get him registered tomorrow.
Okay.
Shankar, are you there?
I have one question.
One moment. Let me just Shankar, have you noted Mr. Shri Singh's number?
No, sir, I have to get that. I'm asking. Yeah.
Just give your number, or you can, if you want to give it separately, you can do that separately also.
I'm giving it on chat box.
Yeah, give it to chat box.
I'll take it.
Okay.
Yeah.
My question is only the MSME creditors who want to put a record of their invoices, can they do so?
Anybody can do. See, IU is an equitable repository. The only thing we require is while submitting of information, you have to register, identify yourself, and you have to submit through digital signature. That's the only requirement.
Yes, but if I'm giving service as a consultant to MSME, they don't have the resources. I am IP, I know this IU, whether I can do if I'm doing.
On their behalf. On their behalf.
Or
you can help them. You can help them do
yeah,
it.
Yeah.
You can help them do it. Of course,
Okay,
madam, again, if you give us contact, so
Yes.
we'll get in touch with you and help you in this.
Sure. Actually, I had tried to record some data, record of default 2 years before, but it was very difficult for that time. It was my first time. Thereafter, I didn't refer this website. But now if I again,
first
again
time is difficult. I'm sure it's not too difficult. And for information for everyone, for record of default, we have a separate number in any case.
Okay.
Any case of record of default, and for MSME creditor also, remember, if he is wanting to submit information of default, he can use the ROD helpline, which is a mobile number.
Okay, but generally he can put his invoices on that, on this website.
Yeah, so you have to only, he can upload any evidence. Sorry, he can give any evidence as proof of default. And basic thing is he has to give his information and he has to fill in that form, which is a not very difficult form.
Okay.
So you can also help that process.
Yes.
Sir, on lighter note, one query is, it is one-way process or two-way process? Suppose I am an IP and my fees and expense has been approved by the COC, and now COC is not paying me the due. Can we do that?
Yes, you can.
Then it's fine. Then it's fine.
The only thing is COC के against नहीं कर सकते, कोई बैंक के against करना पड़ेगा.
Obviously, who are the member of the COC?
सबके against कीजिए. Yes, कीजिए. You can do it. Technically, you can do it.
Technically, I can do it, na?
Yes.
So all my fellow IPs, now there is a good news.
That is an interesting thing.
You can make a bank default.
But only this thing is, अभी आगे आपको बैंक से काम लेना है.
That is the main question.
पंकज जी, लॉन्ग टर्म इम्पैक्ट देखना चाहिए.
सर, ये लॉन्ग टर्म इम्पैक्ट के चक्कर में ही हम अपनी इमेज खराब कर रहे हैं. ट्रूली स्पीकिंग, लॉन्ग टर्म इम्पैक्ट के चक्कर में ही हम अपना बैंकर्स हमें ब्लैकमेल करते हैं. तो फॉरगेट अबाउट द लॉन्ग टर्म इम्पैक्ट.
ये we should have some kind of
be the thorough professional, and whatever assignment you have in hand, you are
I'll
providing
call
the
you back.
best of the service. So it's my request or my suggestion: be strong, be straightforward. Don't chase the bankers for the new case.
that is most important.
thank you.
It has to be. Many,
Yes, yes, yes.
You are right.
This is
You
very
are
important.
right. Absolutely.
Next slide, please. Access of information. Yes.
Acha, isme, just one moment. Pankaj ji, there was one very good suggestion from one gentleman here regarding access. तो वो research का डाल लीजिए ना. यहाँ पे access
Yeah,
जहाँ पे है
we
वो
can do
डाल
23rd.
लीजिए. 23rd में डाल
This is
लीजिए कि
on regulation 23rd.
हाँ.
So there should be some mechanism, the person who is doing the research work.
Yeah.
So there should be some mechanism to share the informations for the research associates. Research associates.
Yes, sir. Yeah, that's a good point.
Either the university will approve that, or whatever mechanism IBBI will think proper.
Yes.
That we can.
I think Mr. Matthew had given this suggestion, very good suggestion.
Yes.
Yes,
That's
sir.
a good suggestion. That's a good suggestion. 24 regulation 24.
Sir, we were at regulation 17.
No, that we have covered now. That is the internal regulations between IBBI and NESL.
वो सब हो गया.
Sir, my name is Satya Devi. I would like to know what is the discretion of the IU when you are accepting the default filed by the corporate debtor. When somebody is objecting, do you look into papers and say there is a dispute, or you have any discretion on that?
We have no discretion. I think Shankar will explain. Shankar, please explain.
Yeah.
If
Your question is?
If the complaint is on very frivolous grounds, there is no ground for it, then will it affect the corporate debtor default?
Corporate debtor. That is, if the corporate debtor files default and then creditor dispute, that's what you are saying, or creditor submitting, CD disputing. Hello? Can you repeat the question, ma'am? Hello?
Yes, sir.
Just
Can you
repeat the question. No, basically she wants to know whether NESL IU has any discretion in the matter.
No.
To accept a default or not to accept
whatever, in fact, only very few people has even access to the information.
Next 24,
electronically submitted, automatically, whatever has to be done, everything process happens automatically. So we don't look at the data at all unless it is extremely necessary, and that too by very few people can look at the data.
True. Now next 25, regulation 25. Annual statement is the internal use for the NESL. That's again 26 is for the internal use.
No, 26 is from we were saying about CERSAI and all, no? We can lift information from MCA CERSAI that it is related to that.
Yeah,
so if you want to suggest
Achha, इसमें भी Shankar, anything we can suggest in the changes, because we don't have this access, the NC access.
Yes,
so
that can be.
इसमें this thing can be given.
Can be, actually it is mentioned 26. You go to 26.
Just 26.
Here it says that they may be notified by the board from time to time. So only they can request.
But till date, sir, the board has not notified with anyone, CERSAI or civil board has not notified.
Yeah. They have not notified.
So I think when the DRT matters will come, then they will notify it on later stage.
No, this MCA data could be any case useful to us, because MCA में corporates का information है. So this can be extremely useful. So इसमें अगर हम लोग ये कर सकते हैं कि this registries could be notified fiscally, then it could be helpful for the IU and for the system also. ठीक है, anyway, it's okay.
That you can suggest, sir. That you can suggest to IBBI or ICSI.
हाँ, ठीक है, we'll suggest.
Yes. These are the duties of IU. I think IP has no relevance with this.
This is duties of the user, sir.
Yeah, duty of the
27 is used.
Chapter 6.
Including an IP who is using the information.
Yeah, I am talking about regulation 28.
Sir, adu mattum sir.
Yeah. Tell me, Satya Devi ji.
I think she's talking to somebody else in the background.
Okay. Risk management, audit, and preservance policy. These are all the internal purpose of IU. Yeah, this is for the IPs.
Now anyhow, as per amended CIRP regulation 39, you have to store in electronic form for 8 years, which can be stored with us. We do provide storage services and many IPs are already using it.
But it's not the mandatory.
No, it's not mandatory. It is mandatory to store. It's not mandatory to store.
Yeah, with you, it's mandatory to store that.
No, it's not that. No.
Okay.
So we have to scan all the documents and then submit here.
Obviously.
Yeah.
Madam, if you are using ICMS, you don't have to scan anything.
Okay.
Everything can flow directly from ICMS to this one.
Okay.
Correct. But the existing
not
you have
using.
to scan and store.
And just for information, Pankaj ji, aapke liye bhi, if you are using our claim management software, you can totally do digital and paperless claim management directly on the software.
That's good.
For existing, you have to do scanning and uploading.
Yeah, existing only. But if you are using ICMS, no scanning is required.
Yes.
It is for the internal purpose.
Sir, do you provide the data for verification of claims also? Is it useful?
Yes. Who is this speaking?
Anil, sir.
100%. Like I said, no, it is there. Or if you have this thing, you can just speak to us tomorrow. We'll get it done.
Sure.
I have a question.
So we can have a demonstration. That's why it's very important.
So ICSI, if you could just organize this, please. Nitika ji, kara dijiye, please, demonstration.
Okay, sir.
I have a question. Can you create a data room for us?
Yes.
Yeah.
Virtual data room.
What will be the cost? What will be the cost?
Bata dijiye cost.
It is, as of now, it is like, 10,000 rupees per month. Generally, we collect.
How long it will take for you to complete the process? Maybe 3 days, 2 days.
If you want it, we can set it immediately.
Okay.
And Mr. Shankar.
Sir, if you can give me number, we can contact. Because we are doing, many IPs are using our VDR auction platform.
Fine.
No, Mr. Shankar, one more thing let me tell you. If you are using our ICMS, then data room is free of cost.
Yeah.
Okay.
Use your ICMS, you can do claim management, everything you can store on the go.
Yeah.
So what is the cost of ICMS?
That same charge.
That is 10,000 rupees per month.
Okay.
And you pay only for the months you use.
Okay, that's fine. Okay.
If there's some stay of something, then you need not use it.
Yeah, that's what I was wondering.
Something has happened,
if there is a stay or not happening anything,
nothing is happening, then you can this thing. And the moment you want to start using it, you can pay and start using it.
Fine, that's a good option. Yeah.
Thank you.
And next, Nitika, next. These all with the IU. Yeah, I think it is all finished for the IP.
Yes.
This software is for IP or for CD? Means it is CD wise or IP? For one IP, I can have 5-6 assignments, suppose. For it is
No,
like
it's CD wise. It's CD wise. You know, you can't mix up the two.
Yeah.
So for per CD is 10,000 rupees per month.
Yes.
Yeah.
Okay.
And see, the advantage is through this software, you can also give access to the COC.
Yes, yes.
Yeah.
It's on the COC.
Otherwise, Vaishali ji, then IPE have the number of cases, then MD of NESL from where he will run his show.
Correct.
Yes. Anyway, I
No,
think
and more importantly, you can't mix up the two. No? It's just a data room,
exactly.
you have to have separate.
So according to you, the registration will be one person will be registered, and the then corporate on CD wise there will be separate registration.
Yeah.
On the same platform.
Yes.
Okay. Separate this application will be created. So
But let me just clarify. This charges etc. only for ICMS. For using the data to verification of claims is free of cost. Using data to verify claims is free of cost.
That's great. That's great, sir. I think we had 282 participants and only 3-4 IPs are raising the questions. So don't take it lightly. Some I am seeing some IPs are attending the meeting in very inappropriate manner by laying down on the bed and all that thing. So it's my humble request to take it seriously because it is in all the beneficial interest of the VIP. ICSI, IIP conduct all the seminars, not for the CPE hours, but for the educational benefit and for the upgradation of the VIP strength. So take it seriously. It's my humble request to all the fellow IPs. And it is our fortune that MD of NESL is present in this seminar with his whole team. So we take out as maximum benefit we can take, as maximum questions we can raise.
Whether you have also, can you, if you have also the kind of application wherein the timeline is notified, suppose and etc. That's very important aspect. They're notified or through email.
You will get timelines for every activity provided in CR or liquidation.
Okay.
Under CMS you can get.
Yes. Every activity is provided. You will get, I think, 1 week before it's due with
prior notification features is there.
Yes.
That's a very handy software.
Yeah.
Can I get the contact number of some officer, Mr. MD?
Shankar, you can give your mobile number if you don't mind.
In the chat box, I can.
I have already typed my number. I will type it again.
Madam, just give you can just give your name, so we'll send you a mail. You know, Vaishali, right?
Or some email address, sir, that will write to you.
Yeah. So our email you can use Shankar.
We will take it from IPA. You just give the names.
No, mobile number you're not getting.
I have typed my mobile number in the chat, sir.
Yeah, so you can just note down. You can contact us, and you have Nitika's mobile number, na? So Nitika, you can, Shankar ka this mobile number we are. Any case, my mobile also. My mobile is also in public domain. Kuch nahi hai. You can give my mobile number also. No issues. But generally, I am usually quite busy, so I'll not be able to take calls all the time. So Shankar ka le lijiye. And similarly, if you have any queries from IPs, so please pass it on to us.
Ritika, we can do one thing, na, ki at the time of sharing the emails with all the IP of minutes of this webinar, so we can share the participants' email ID or contact number. And
yeah, if you can give that, will helpful.
Yes, yes. So any other questions? Queries from any IPs? So I think Nitika, you should take the charge.
So thank you so much, Chaudhuri sir and Shankar sir from NESL for participating in this webinar and for participating in the webinar and for making all the insolvency professionals aware about your services. We will shortly have another session also specifically on the services, and the demo may be shared in that webinar. And thank you so much, Pankaj sir also. The minutes will be shared accordingly with all the IPs.
Thank you, Pankaj ji. Thank you all the IPs.
Thanks a lot
Thank you.
for your kind celebration and kind presence.
Thank you.
Thank you.
Thanks for wonderful session.
Thank you.
Thank you.
Thank you, sir. Thank you very much.
Thank you, sir.
Thank you.